Also, next month's Lunch and Learn is on retirement planning or financial planning for retirement. And that will be over the lunch hour, third Wednesday of June. Now, it is my great pleasure to introduce Edith Picciolo. She has a vast experience. She was an attorney at Hawley Troxell. Most recently, she was the Deputy AG at the Natural Resources Division for the Department of Lands. And she recently was promoted to lead Deputy AG at the Department of Labor. So thank you for being here.
Thank you. You know what? I was thinking this morning, I've done jury trials, and that's not nearly as intimidating as you would for peers. So thank you all for being here. I'm happy to do this. This is a topic that for some reason I really enjoy. I don't know how I fell into contracts. I hated contracts in law school. But over the years, that has been the theme of my practice, and I've come to really have a different way of looking at it than what I learned in law school. So when we formulated what to do here, I mentioned that I have a 4-hour workshop thing that I do on contract drafting, because I work with so many state agencies where they're drafting their own contracts, and then we just get to review them. And we realize there's a problem here. They have people doing contracts that really don't know what they're very much about contracts. So we developed this 4-hour workshop where we do a lot of hands-on. Here, fix this provision and explain different things as to why things are important. So what I have done here is I have called out the top 5 things that I could think of that I think are the most helpful when you're thinking about drafting contracts. So we are going to fly through this material because you all are seasoned practitioners, and I don't have to stop and explain a lot. But think about this as coming from the perspective of how you can think about using some of what I'm saying here as a way to help your clients understand what it is, why you care. So I hope that is a helpful way of looking at it. So when I give this presentation, and I've done the 4-hour version many times, the feedback that I get is that I need more cartoons. Okay, I can do that. So I spend a lot of time looking for the funny cartoons, and you can see that this is obviously somebody who is trying to rack up billable hours, but never use one double negative where no triple negative will not prove unnecessary. I like that. That was hard to come up with, I think. So, and then here, I use this one as a way of explaining to my clients why I ask so many questions. They send me these drafts, and I call them and I go, wait, what do you mean by this? Who's going to be doing this? What's that? And what they're saying here is, here's a dilemma. Should the disclaimer for our client's new sleeping pill read may cause drowsiness or may not cause drowsiness? So it really depends. Are you the one trying to sell, trying to sell the sleeping pills, or are you a regulator that's trying to make people aware of the side effects? So I think clients relate to that. They understand why I have to ask so many questions. So the context and the intent, this is what intent, I keep saying to my clients, So, and then we also talk about these 4 things. The client will say, oh, Edith, you worry too much. I have a good relationship with the vendor. I'm sure you've all heard this. I know Joe, I know Bob, whatever. If we have a problem, we'll work it out. We'll talk about it. We both know what we meant when I try to pull apart. Well, what does this mean? What does that mean? They say, "Don't worry, we know what it means." And then the one where I really try to focus in with the client is they say, "Well, because I always say, look, I'm writing this in case we ever have to litigate. In fact, I'm writing it so we never do have to litigate." And they say, "Oh, well, we'll just explain it to the judge." Okay, and you can understand from a lay person or non-lawyer point of view why they think that's a good answer. But so my tip number 1 is remember who you are writing for, And who you are writing for is a judge. And have I ever litigated a contract? I've never had to go to a jury with a contract dispute, but we've had some serious, contract disputes. You all know the Serena case, you've heard about that. So you're writing for the judge, even though the client doesn't want to hear that. But what I say to them is, look, if I'm not here tomorrow and you're not here tomorrow to explain this to someone, this needs to speak for itself. So we'll talk a little bit more about tip number 1. And that is the parole evidence rule and the plain meaning rule. You're fresh out of law school, right? So you remember that stuff. This is my bread and butter. In law school, I was like, what is he talking about? I couldn't understand the parole evidence rule. It seems so archaic, but I now live and breathe by the parole evidence rule, in case you've forgotten. And I'm kind of glomming together the parole evidence rule and the plain meaning rule because it's all a package, in my opinion. So absent ambiguity, the party's intentions must be discerned from the 4 corners of the document. And so I take and I go to my client, see, this is 4 corners. This is it. Everything has to be in here. It's not like in a side letter. It's not in a note in a file. It's not in someone's brain. The whole point of contracts is all in one place so that nobody has to argue about it and so that commerce can run smoothly. So I think that helps clients understand that. And then if there is an ambiguity, and you can see where I bolded these words because I want to make sure my client doesn't hear what they want to hear, which is, oh, so I can get the evidence in. No, what I'm saying is it might be introduced, and all it's introduced to show is that what your intent was at the time of the contract, at the time of the execution of the contract. And it's not what we think it means today or what we wish it meant. You can introduce evidence to show your intent at that time. So my first emphasis is don't think you're getting any extrinsic evidence in. And also, the whole thing of letting evidence in is really a fallback for courts. There's a lot of other, she told me not to touch it, she was right. There are a lot of other, see it goes forward if you touch it. I touched it by mistake. There are a lot of other ways of interpreting contracts before you have to fall back to the parole evidence rule. So think of it as a last resort, okay? So, so then what is an ambiguity? Well, that's in the strictly speaking, in the legal sense, it's anything that is reasonably capable of 2 or more meanings. And you'll see later, I tell my clients, it's anything I don't understand. It's anything like, what is that? And I'll give you a few examples as we go through here. So that's the strict interpretation. But if you read it and you don't know what it means, you need to understand what it means to help your client flesh it out so that anyone off the street could read it and go, okay. Or an expert, if your client can say, there will be no disagreement among experts about what that word means. But if you have warring factions within the expert community, you've still got a question of fact there. So I come across this a lot. We do business with a lot of Canadian companies and we use dollar. Well, a dollar can be a Canadian dollar or a United States dollar. So that's capable of 2 meanings. So you need to explain that to yourself. Now, I give that as a stupid example, but it's fun, and you can share that with your clients, then they'll get, so what's one way of interpreting that sentence?
Stand in the locker.
Right, it's what they have to wear it in the locker. Obviously, we know that's not what it meant, so it's not reasonably capable of that. But you can see how wording you really gotta be careful. And then, another one, execute. Well, it actually has 3 meanings because it can mean to kill somebody. But profits, net or gross, that's an important one in business. It's obviously really important. You can fight over that all night day. Biweekly, liability and debt. If you're in some situations, people think liability and debt mean the same thing. So you really need to know your industry. So I'm just giving you those as examples of pretty common things that could be an ambiguity. And as I told you before, my rule is, I don't know what it means. So that to me is an ambiguity. And those are the ones that I actually come across more. You probably do too. You're working with industries that you maybe, they have a lot of technical jargon that you don't understand and that type of stuff. So if you don't know what it means, you need to find out what it means, because either an expert needs to be able to explain it, or you need to, I'm going to say, dumb it down, simplify it, so that anyone can understand what it means. So the tip number 2 obviously follows from tip number 1, is to clarify ambiguous terms. Now, we'll talk about an example in here about industry jargon, and I really think that's important. As you get into your industry, your client's industry, you'll learn the jargon, but you have to remember it's because you know the jargon now, and you're still writing for a judge who might not know the jargon. So try to have be cognizant of that you don't get too enmeshed in that. And it's important also for clients to understand that ambiguities are interpreted against the drafter. And I know this is like basic law school stuff, but it's basic law school stuff, and that's why it's important. It's in law school for a reason. If it could be interpreted 2 ways, the court will rule in the way that's most beneficial to the person who did the right contract. That's my way of trying to explain what that rule means to clients. Yeah.
I've been seeing a lot of contracts lately where, even though it's one party and one party's attorney drafting the contract, there's this term of both parties mutually drafted this contract and it won't be interpreted against either party. Have you seen that actually play out one way or the other?
I have not researched it. I see it a lot lately too. And in fact, I like it. I use it. I think it's better than nothing. It's going to be some evidence so that you don't have to introduce evidence as to who wrote it. If it's a boilerplate contract, obviously there's no way, like an adhesion contract, you're never getting that type of stuff in. But I haven't seen whether it works or not in litigation. Has anyone else seen it? But I think it certainly couldn't hurt. And does everyone know what Joy's talking about? Yeah, that provision. So I use it. I think it's a good practice. I don't think it's foolproof. Nothing is, unfortunately. Okay, so here's another example. And by the way, I am whizzing through this, so if you do want to stop, that's more interesting, because you can always read my slides. So read that one to yourself rather than me reading that out loud to you. Now, guess what they argued about in that case? Because I put it in bold blue letters. Include. What does include mean? And of course, the client argued that include is a limitation, and they shouldn't have to pay for anything that's not on the list. And the lawyer argued that include was a term of expansion. And I can't remember how this case actually came out, but the point I'm trying to make is that even a simple word like include can be ambiguous. So how you could fix that, including but not limited to. Best phrase ever. And I know you're thinking of boring lawyer stuff. It works. And it's important because that is a rule of interpretation. And if you don't use it in one place and you do use it somewhere else in your contract, because of the 4 quarters rule and all the rules of interpretation, the court will assume you didn't mean to include it. So include. Okay. So another example, licensee shall deliver to licensor quarterly sales reports and litigation reports requested by licensor. This is a real one, a real example that I have. And so here does requested by, this phrase here, requested by, modify both the sales reports and the litigation reports, and does quarterly modify both of them as well? So I'm not going to bore you with how you could have rewritten that, but take it home, think about it, and think about what you could have done. But what you see here is I can't answer that without asking my client. what did they intend? I can't help them rewrite it. And that's, so what I do is I take the whole contract, I hold tiny, I use a pen, I print it out, and I write all my questions, and then I call my client and say, okay, do you have 2 hours? And we go through it, and then I pick my battles. But so that's one where I have to say, what did you mean by this, and we clarify it. So do any of you remember this case? And I'm sure I'm mispronouncing it, but Friglement? Friglement. Okay. Did you have that in law school recently?
And
Okay.
both contracts and sales.
Do you use that in your class at all?
No.
Well, I should have you teach this part, but this is a good case just because it's kind of funny, the chicken case. You should go read it. There's a lot in there. I'm just kind of pulling out this one issue, but there's a lot in the case. The issue in the case literally was, what does the word chicken mean? And of course, the plaintiff says chicken means a young chicken that's suitable for broiling and frying. And the defendant says a chicken means any bird, including a stewing chicken and the pejorative term fowl. And of course, if you look up chicken in the dictionary, like Webster's or whatever, according to the case, you'll get both definitions, okay? So, this is kind of funny because it's chickens, but this was, this meant a lot to the litigants. They litigated this pretty far. So, this is their business, the chicken business. So this is why you kind of need to know your industry, as we'll get into in a little bit. So the cables between the plaintiff and by the way, I'm not even sure what a cable is. I think, today we say an email, right? Yeah. Morse code or something. So it was a German company and an American company, and they argued over the word Hund and Brachhund and Suppenhund. And so the plaintiff argued, hey, you know what, you knew German. You should have known how to use all these different words. So, you can see how obviously somebody got in parole evidence because chicken was ambiguous. So this is what you'll get down to. There were experts on both sides. They had people from the USDA testifying about what chicken means. They, all kinds of experts and stuff. So people take this stuff seriously, obviously. And so there were two experts and they introduced the USDA definition from the regulations. And the defendant said plaintiff's interpretation is unreasonable because of the price. So they're trying to say, look, at this price, you couldn't have bought that type of chicken. So it was obvious on its face what type of chicken it was. So I'm just giving you this as an example of all the different types of evidence and why, if you ever have a chicken case, you need to identify. So the defendant's interpretation ultimately was supported by one of the dictionary meanings, the USDA regulations, which the contract referenced. There was market data that they had an expert introduce, the plaintiff's statements, out-of-court statements, extrinsic evidence, that he wanted any kinds of chickens, and they accepted the first shipment of chickens. So all that stuff is parole evidence. Don't ever accept the chickens. So I have this case here. This is the site, sorry, but the first two cases are the ones you want to read. In the interest of time, I'm not going to go through it, but it's a really good case for understanding. And I would suggest you take that case, read it, and see how you would have rewritten the infamous paragraph 9 to reach the result. But either take the plaintiff side or the defendant side and see what you could have done to get a better result in that case. So I have a few examples here of how to spot and remove ambiguity, but I'm going to make you do one of them for you, and then the rest you could do on your own. So an accounting, what do we have till 9:15? Okay. An accounting, this is from a real contract I was asked to review. An accounting system acceptable to the state will be established by the association to track its expenditures for salaries, blah, 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 in the annual operating plan. Now, the things I highlighted in red are the things that I felt I couldn't understand, and that would be, and it's not so much, oh, well, Edith doesn't understand it, we have to fix it. It's, these are areas where people will disagree. Notice provisions, reporting provisions, and document sharing provisions. And I think I have a slide on that later here, but those ones are the ones in my experience, and if anyone has a different experience, let me know, where you will have the most disagreement if you don't draft them correctly, because those are the day-to-day parts of the contract. You have to notify me on this day to do this, blah, blah, blah. So you want to really look at, you know, what are the practical parts of the contract that people are trying to use the contract on a day-to-day basis. And you want to be able to say when there's a disagreement, did anyone read the contract? And say, see right here, no, you must notify me by blah, 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 by fax or whatever. So, so this is an example where, I mean, I'll ask you guys, what do you think the word system means? Anybody? What does it mean to you? A computer system? Anybody else?
A set of procedures.
Procedures. Exactly. I didn't know if they meant Excel. Like we're telling you have to use Excel because you're going to send it to us and we can only accept Excel. A spreadsheet, you know, for accounting, or do they mean Lotus 1, 2, 3, or do they mean you have to have a system? Like I pick up this document and I put it over here and then I do that. That's a system too. And this matters because this has to do with funding and all kinds of this is firefighting and stuff. So it isn't that I'm just picking it apart for the fun of it. I'm saying you're going to have a disagreement over what you mean here. And then established, you know, my question was, well, established when? You just say it will be established, meaning, when, you know, when? And then it says to track its expenditures. And again, in context, we didn't know whose. So watch out for your pronouns there. And the annual operating plan, as we'll get into later, we ended up making that a defined term because it wasn't anywhere in there. What is the annual operating plan? So I'll give you this one real quick. I give them to you in exactly the format they came to me. So with quotes, air quotes, train the trainer, you know. And then is this the one? Oh yeah, it says power users. The project team will be an integral part of the project and will expect to be power users.
Wow.
Right? So that's an example where I had to ask my client, does that mean something in your industry? Because this is from an RFP, which is just as important as a contract. So when they submit their proposal, are they going to read, you know, when they read that, are they going to say, oh, power users, right? You know, or are they going to say, what the hell is a power user? So, you know, they explained it to me, and believe me, we rewrote this whole thing. So they did, but if they could have said, oh yeah, everybody knows what a power user is. And if they say that, then fine. I'm not, you know, if they say everyone in this industry, they know better than me. So you just, you know, you have to use your judgment there about how far you're going to drag your client through the coals. I'm going to go more quickly here. Okay. So my favorite one, and I don't know why I don't make this tip number 1, but I think because the tip number 1 and 2 are more legalish. But tip number 3 is avoid passive voice. If there was one thing that I could make everyone do is do not write contracts in passive voice. And you're all nodding your head, so we're going to whiz through this. But if you don't know what I mean, please stop me or, you know, ask. And there are some good examples here that will bring it home for you why I say that. You know what it is, it's the conjugated form of to be. So when I was in law school, I had a teacher who, you know, the writing class that you have to take in your first year, she would go through anything you handed in and circle all forms of the verb to be, and then she'd hand it back to you. She wouldn't even look at it until they were gone. So is, are, was, were, be, and been. I'm sorry, I should have written them in here, but you all know what they are. So if you see any of those, you really scrutinize. I'm not saying it's never appropriate, but it's almost never appropriate in a contract. This is not creative writing. We're not looking for different ways to say things because it's getting boring, right? and I do think clients think that sometimes, that it's boring if I start every sentence with the contractor shall. Well, that's fine. So I gave a couple examples. If it is determined that, and work may commence when the notice to proceed has been received, and we can split hairs over the difference between passive voice and what is it, nominalizations or whatever the other thing is, but you get my point. Just don't have the verb to be, because you could fix this by putting has been received by so-and-so, but that's still bad writing, and you have more words than you need. But we're gonna fix it, okay? My assistant insisted on having some cute stuff going on. I think that's the only one. Okay, so the way I changed those previous two sentences, determines blah, 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 not if it is determined by somebody, or the contractor may begin work when it receives a notice to proceed. Structure should be subject, verb, object, and we're going to have a few more examples here of why that's important. So this one is my favorite one, okay, and let's just say it's from a different state where there was because I did work in another state as an attorney, as an assistant attorney general, where they have a contract for the healthcare at a prison. Okay, and so they send me the RFP to review it, and this is one of the sentences. Now, what is what? Right? So, well, let me ask you, what is it? One person, anyone in here? What do you take a guess at what? Pretend you know what RDU is. Don't worry about that.
RDU is supposed to do a mental health screening.
Okay. What's another way of? It could just be, hey, FYI, right? Because it's an RFP, and RFPs sometimes have a bunch of sort of background information. I read an RFP, I don't know if they want that to be a contract term, or if they're just saying, by the way, these primary assessments happen here. So there's a lot of ways you could interpret that, but let me tell you what it really meant was this. So that is a case where I just had to ask them, what do you mean? So there's no substitute. You can't sit in your office and figure it out. This is an interactive process, okay? I just think that's a good example. So I give a few examples here. I think I fixed that one. Oh, I know. These are just examples for you guys to maybe try to fix on your own. You can see. Some of them I think I went ahead and tried to fix. So here is, whenever an emergency fire condition is determined, mutual assistance shall be provided. So you don't know who's doing what. So, and I want to say this about the RDU one as well. That's a situation, again, where it isn't just me trying to think of things to bother my client about. It's because this is a private prison. So you've got the people running the private prison out there doing stuff. You've got this, there are some state employees who work at the prison too. And you've got the the healthcare contractor. So there were three potential people, that they could have been saying should be doing this screening. And so I have to know that context to know to ask the question, well, who's supposed to be doing this? And so similarly here, obviously in a contract you have at least two people. So the question is, who's doing what? Mutual assistance shall be provided, and is when an emergency fire condition is determined. And it's pretty important to know who's determining that. Believe me, in the context, you don't even need the context. But so I tried to fix it like this, and you guys can read it and decide if you like that. you can, do it another way as well, sure. But I just wanted you to see an example of how I would go about doing that. Does that make sense? Okay. And I have a few others here. I'm not to bore you with them. So, and then here's one again where when you fix it, you might get to the point where you don't know. You get it in an active voice, but you don't know something about the sentence. So here I just put in brackets, someone has to do something. So when you get it written the way you like it, you still might have to go back and say, who's this? Because from the sentence, you cannot tell. Okay. And again, I had to say support to someone. Okay. So tip number 4 is use definitions. You're all, you've all done this, but I really was one of my top 5 tips. It's for a reason. A term really should just have the definition of it, rather than having to state the whole thing again, and you all know that. Ways of doing it, and there are different things for when, especially if you're like me and you get drafts that you're reviewing that other people wrote. There's a couple ways to do it. One is use that big long definition section at the beginning, put it in alphabetical order. How about that idea? Makes it very helpful. And I like that a lot. But if you use parentheticals, within the like a shorter contract, that's fine. But here's where I like to bold that first time you use it, right? So you can find it. But not every time. There's no need to do that. And then every time you use that word, you have to use that initial cap. And clients do this. They do the opposite. Sometimes they capitalize things that aren't defined because they think it makes it seem more official or something, or like, oh, everybody knows what that means now. And that's really a bad practice for a lot of reasons, which I don't need to explain to you. But look for those and get rid of them. And then every time you use that defined word, use that initial cap. And here's a tip: don't use find and replace. Like once you decide, it makes more sense to say contract instead of agreement for some reason. I'm going to add to my examples here. I did this, so I like to share my own stupid stories. I recently did this where I changed the word owner. No, I changed the word state to owner because it was like a fiduciary type of contract, and it was who owns the asset, and that was just the convention in that type of agreement. So instead of saying the state, I said the owner. And then I shared the draft with the client. Yes, I'm telling you all my stupid stories. And noticed, as we were doing it together, that did not work out too well because then I had the United States District Court for the state of Idaho. So it was like the United Owner Court. Like I changed the word state to owner. So don't use find and replace it. You think it's easy, and you can use it, but don't say replace all. Don't go through. And I've had this happen where clients decide in a later draft that they wish they had used a different word. And believe me, it happens enough that it's one of my tips. You know what I mean? So property, changing property to deliverable. Then we have the intellectual property section in the contract. So every time it said intellectual deliverable. You have, I guess part of what I'm saying is you have to read every word. Don't think your client is doing it. Okay? Because they're not. Don't put operative terms. This is really popular to put to have a contract term, a definition, and then stick everything in there. And the reason it's not a good idea is, number one, some courts could use rules of interpretation that say definitions are not an operative or substantive part of the contract. So you certainly don't want it there for that reason. Hard to find. You'll say, oh, I knew somewhere in there we said that the COR can't modify this, where it, and you're looking and looking, you would never think to look in the definitions. So it's just a bad practice, and that's a hard one to explain to clients, or a hard one to get clients to agree with you about, because they just want to cram it all in there. So this blue sentence here is my example of what shouldn't. Here's one incident commander definition is almost all operative stuff. In fact, I don't know why we would have a definition of incident commander, because this is all the juicy stuff. It's not a definition, so don't do that. And so on the same vein as definitions, I want to talk briefly about trade usage, which we've touched on a little bit here. And here's the rule of trade usage, sort of the black letter rule. And you know, always do research in your own state before you quote Edith on contracts. But so basically, when one of the parties is not a member of that trade group, then I changed all the his's to hers because I wanted to see what that was. Her acceptance of the standard must be made to appear by proving either that she had actual knowledge of the usage or that it's so generally known that you can infer. So if you have, like in the chicken example, if one of those people had never bought chickens before, and the other one was like a major player in the chicken industry, then one of the, and they said, look, Brahman means broiler or whatever. Everybody knows that. You should have known that. Then you could say, I never knew that. I'm just some guy off the street who bought a chicken one day. So that's what that rule is getting at. It's sort of just a fairness, right, of what terms of art mean in this particular industry. You need to know what those are. And you might think chicken means chicken as a lay person, but you need to know your client's industry to know what. And so interacting with definitions is, well, should we have a definition in the definition section of chicken? Or is it so obvious and the other party that we're dealing with knows what chicken means, there's going to be no disagreement, and we're not going to get experts to argue over it. But as you can see, most industries, you are going to have experts argue over things because who knew about chickens? So, here's chickens again. And this was interesting here because they tried to argue that that trade usage should apply. But the defendant was able to show that usage of that word was pretty new in that industry. It had only been around for 2 years. So you can see the level of evidence that can come into play here. So you really need to know your own industry and decide what should be in the definition section. And terms of art that we know of, like agent, contractor, fair market value, you can think of a million others, but they have dual meanings. Some people, to us as lawyers, agent is a legal concept, and there are elements to it to see if someone really was an agent of a principal. Same with contractor, because that could mean versus an employee, an independent contractor. It has to do with control. It could have to do with strict liability for dangerous activities and whatnot. Fair market value in my former industry of eminent domain, that had very strict meaning, but people throw it around a lot. So be aware of what things, and I'm just giving you some examples to make that point. Be aware of what terms of art exist in your industry that you might want to make sure people know exactly what you mean or don't mean. Okay. Let's skip that one. Okay. So the tip number 5 is to avoid drafting by accretion, and I have the Martha Stewart case as an example. I did not put the whole thing in the slides because I wanted to see if we would even get this far. But I have the citation on the slide, and I want to go through it with you real quick because well, you'll see why. Okay, and what I mean by accretion, I think you all know what I mean, but we're just building and building and building and building. I send you a draft, you mark it up and send it back to me, I send it back to you, and before you know it, we have this big, long sentence. And that's why go look at that insurance case that I cited earlier. You'll see there is no period in that. It's like this long. bad drafting. So that's what I mean by accretion. It's going to happen, okay? There's no, that's just how contracts get negotiated. But what I'm saying to you is go back and read it. Or have someone else, if you can, you know, if you have the luxury, have someone in your office read it to see if it's still making sense. And you'll see why, and I know you know why, but let's use the Martha Stewart case. I mean, don't forget the basics, right? This is what this case stands for in my mind, because it involves the parole evidence rule. It involves ambiguity. It involves that provision that you've all put in a contract that says a waiver of one provision or one time is not a waiver for forever. Now this is Macy's, JCPenney, and Martha Stewart. Okay, major retailers with high-priced lawyers. They all should have known better. But I think the problem here was contract by accretion. So in the Martha Stewart case, I don't think I have a slide on it, so you're just gonna have to listen to me explain it for a minute. And I encourage you to go read it. So Martha had a contract with Macy's, and that gave Macy's the exclusive right to sell, a defined term, exclusive product categories, okay? So Martha and Macy's have that contract, but there's a carve out from exclusive product categories. And it says Martha can sell exclusive product categories in Martha Stewart living stores. And that's a defined term as well. So what that definition was like if it had 4 walls, and it was it's sort of like if you looked at it and you knew, like, you know, when you go into JCPenney, is it, and they have what's that company called? Sephora. I was gonna say Euphoria. Sephora. You're like, wait, am I in JCPenney's or am I in Sephora, right? Or at least I am. So that's what a Martha Stewart living store would be, is like a store within a store. So Martha sees, ka-ching, an exception to this exclusivity that she's given Macy's, and of course she enters into an agreement with JCPenney to put those Martha Stewart living stores in the store. And of course Macy's sued, and you know, they said that's the way you did that is not within that exclusivity or that carve out from exclusivity. And so of course Macy's wants the court to consider parole evidence, and the court says no, there's nothing ambiguous in here. So, you know, like these concepts you learn in law school, they play out in real life in high stakes litigation with major retailers. So Macy's argued that the store within the JCPenney does not fall within the definition of the exception, and the court disagreed with that as well. So you might think, okay, so Martha Stewart and JCPenney won, right? But the court literally said, not so fast, in quotes. The court said that, guess what? That store that was within JCPenney violated another part of the contract, which was the non-compete. Well, none of the parties had ever brought up the non-compete. So pause. My point here is you got to read that contract. And I know this is contract by accretion where they just forgot, oh yeah, there's a non-compete in there. I mean, I'm guessing, right? But that, you know, people throw stuff in. Oh yeah, let's throw a non-compete in. Let's throw the waiver thing in. But they're not really thinking about it. So you might think the story's over, but it's not. So then JCPenney and Martha argued that, you know what? Macy's has always looked the other way whenever Martha entered into these deals with Emerald. So, you know what? You've waived your right to challenge my use of that carve out in the exclusivity. And the court says no, because you have that no waiver clause. And, you know, when I read this case, I was like thinking, well, this is going to be a complicated case. This is going to be, you know, lots of numbers and stuff like that. And in fact, you can go on YouTube and watch some of the testimony. It's pretty interesting. It was did any of you hear about it at the time? And they settled out of court. So after they lost it up, that's a motion for summary judgment case, the one that I cite there. So, you know, so my next example of contract by accretion is this. Got it?
Yeah.
Yeah. Now, I take this example from Charles Fox. He's a lecturer on contracts. If you ever get a chance to go see any of his CLEs or anything, I recommend it. So this is a real case that Charles Fox gives. You know, and so yesterday I said, you know what, I'm going to challenge myself to see if I can fix this. And I encourage you to do it too. So here's what I came up with. So what I did was, I broke it down by concept. So the drafting rule is general stuff first, and then you use, don't be afraid. I know that my first slide kind of made fun of using subs and Romanettes and whatnot. Don't be afraid of them, they're your friend, okay? So this is the technique I used. First, I said what the first sentence they're trying to get at was just the grade of the mackerel. And if you go back, you'll see that first sentence talks about the grade, and then it tries to throw in a parenthetical. It never use parentheses. Maybe I should make that tip number 6. Parentheses don't belong in contract, because what do they mean? What do they mean? If you're the judge interpreting it, it means this is lit. Rules of grammar, it means something that you could take out and not lose the sense of the sentence. Well, in a contract, every word should have some meaning. So I don't ever use parentheticals. So, but you see how they tried to throw in through the parenthetical something about the delivery date. Having in one sentence too many concepts. You've got the grade of the mackerel and then the delivery date, and then you've got an exception to the delivery date. You know. So what I tried to do was make the first sentence period. Okay, this is about the grade, and then it seemed to me what they were trying to get at was there was a general rule about when delivery should happen, and then there were a couple of exceptions. And I used the notwithstanding the foregoing. You can use provided, however, you could use, you can use whatever you want. But colons are your friend, and semicolon. Well, you might think this is so basic, but some people forget to use the or the and. Is it and or is it or? And they just have a list. And that's not what you want. This isn't a list. These are two alternatives, okay? So that kind of stuff really matters when you're drafting the contract. So you can see that when I got, and by the way, I have no idea if what I came up with is what was intended by that sentence. I think it's pretty close. But you can see that when I got to the bottom, and if you draft it clearly, you'll find out where the gaps are of things you still don't know. And I couldn't figure out, exactly what they meant about this, B. I'm not going to bore you with it now. But see if you can. And the other thing about this is, isn't it easier on the eyes? And that matters. Believe me, especially if you're ready for a judge. You don't want it. In that example, the AUI insurance that I gave you the citation for, I tried to draw a diagram of that sentence. I didn't get very far. So you don't want to be drawing diagrams of your sentences, okay? So I hope that helped. But you can see, this is an example of accretion where the parties knew what they meant. They're like, oh yeah, no, and I could just see the person with their red pen, like putting it in, like right here, put colon and less, blah, 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 right? And somebody just typed it up that way. Sometimes you take that as your draft and go, okay, I gotta start back. So what I have here is an example of an entire contract that was really accretion, where people forgot to go back and really understand how every part interacted. That's the Martha case, where they did not go back and understand how, like, the exclusivity thing and the carve-out would interact with the non-compete. There's nothing wrong with saying notwithstanding the non-compete in section 4, right? If that's fine. That's great, actually. But so if you have things where you think these could be these could be in conflict. Remember, a court's gonna try to make sense of everything in there and assume you meant everything in there. That's a rule of interpretation. And so they're not gonna say, oh yeah, they forgot, they didn't mean the non-compete thing, obviously, right? And the waiver thing, that's another one. So when you're, so I give you this homework to try and go write that paragraph 9 from that AUI case. And so here are my lessons. Please don't call anything boilerplate. You know, you can call it that, but don't think of it as that. And if you look up the definition of boilerplate, it's like literally some big piece of metal that you hammer onto something else. I mean, it is, but the point is, it's one size fits all. And there, you may have your own little secret list of boilerplate stuff that you like to throw in every contract. That's fine. I'm not saying rewrite from scratch, but think about it, right? And a big one for this is termination clauses, especially at the state, because we have so many termination clauses. And then people want to write their own for that specific situation, and you have to say, well, wait a minute, how would that interact with this one? Because they threw in the boilerplate ones. So, number 2, understand how it all interacts. Use subparts, multiple sentences, whatever you need to make a long sentence clear, okay? And then I gave you my top 3 draft notice provisions, things that have to do with sharing documents and information, and reporting requirements. I had a case where somebody was supposed to give us information, and we didn't say in what format. And so this was at the end of a contract. The party was mad at that point because we weren't renewing the contract. And they said, oh, you want your information, here it is. And it was in some program that no one could understand. We didn't have the software to read it. We had to fill out we needed it to fill out some information to report to the federal government because it was a grant. Then they said, oh, you can't read it? Well, for $10,000, we can read it for you, right? So think about that. Think of end of contract and notice provisions. I can't remember how we resolved that one, but and if you have a specific format that you needed in, then say it. Or just say in a format to be specified by us at the time. It might work. I did. I got through it. So, any thoughts or questions, or I have this whole list of miscellaneous stuff, but avoiding wordiness, you all know that. You don't need that. Notifications, as we talked about, you need to say when the notice was sent, the date. Let me back up. You need to say when it was effective. When is it effective? The date it is received. Because it'll say something like notice shall be effective within 10 calendar days or something like 10 calendar days of what? Okay, those types of things you really need to think about because they will be the source of a dispute. And the format, written notice, telephone, whatever, those types of things. So yeah, thank you.
Thank you.
I just want to put in a plug, if anyone has ideas for the next Lunch and Learn cycle, we're starting that cycle. Our meeting's May 25th, as Wendy mentioned. Email us your questions, and don't hesitate to say that you have a topic you'd like to present. We'd love to hear from our members. It doesn't have to be some, outside person or whatever. So we all have a lot of expertise to share. And if you want to vote on the topics, then come to the meeting or call them to the meeting.
Don't forget to sign the COE form.